Have you been dismissed from a job in a way that didn't feel fair? Hi, I'm Simon Dippenaar and I'm an attorney. South Africa's Labour Relations Act, or LRA, protects the rights of all parties, prevents discrimination and maintains a balance of power between employer and employee. Employers have a duty to treat workers fairly and follow correct procedures for terminating employment. Unless an employer has a just cause for dismissal, it is considered unfair. If this happens to you, now what are your rights? An automatically unfair dismissal is defined by the LRA as distinct from ordinary dismissal. Ordinary dismissal might occur due to reasons concerning an employee's conduct, capacity, or the operational needs of the employer. The dismissal is considered automatically unfair if the reason for it is what the law calls egregious. This means extremely bad in a way that is very noticeable. Employees are entitled to protection against unfair dismissal. Employers can only terminate their employment for reasons recognized by the law, known as substantive fairness, and following a fair process, known as procedural fairness. Unfair dismissal often stems from the violation of fundamental rights. Some of the reasons for classing a dismissal as automatically unfair include exercising a right granted under the LRA, participating in proceedings governed by the LRA, engaging in or supporting a protected strike or protest action compliant with the LRA, refusing to perform work typically done by employees on strike unless that work is crucial for safety, rejecting an employer's demand related to mutual interests such as pay reductions, any pregnancy-related issues, involvement in lawful trade union activities, direct or indirect discrimination, for example, based on race, gender, age, disability, transfers related to business transfers or insolvency as outlined in the LRA, making a protected disclosure under the Protected Disclosure Act. You may know this as whistleblowing, reporting unlawful or unethical conduct you observe in the workplace. If you've been dismissed and you think the dismissal is unfair, you can challenge the dismissal by registering a dispute with the Commission for Conciliation, Mediation and Arbitration, CCMA. The CCMA is an independent statutory body established under the LRA, and its purpose is to conciliate workplace disputes and arbitrate disputes that remain unresolved after conciliation. Depending on the industry you work in, you may be advised to take your dispute to the Industry Bargaining Council if there is one. The CCMA can advise on the appropriate channel for your matter. Anyone can register a dispute with the CCMA, and there is no fee to do so. A labour lawyer may complete and submit the forms on your behalf, but this won't influence the result or speed up the process. However, be aware that the CCMA cannot arbitrate disputes unless you and your employer consent to arbitration in writing. If your dismissal is found to be unfair, you will be able to be reinstated or re-employed or receive financial compensation. What's the difference between reinstatement and re-employment? Reinstatement means to get your job back, as if you were never dismissed. Re-employment means you go back to your job, but as a new worker. However, the process of raising a dispute with the CCMA can often sour your relationship with your employer. It may be unpleasant for you to work together again, depending on how much direct contact you have with the person who dismissed you. You may also fear that your employer will make your life so unpleasant you will resign. Thus, they achieve the goal of getting rid of you without the cost of retrenchment or compensation. In this case, you can opt for compensation. Compensation is likely to be awarded if you don't want the job back. The circumstances surrounding the dismissal would make the relationship between you and your employer intolerable. It's not reasonably practical for the employer to take you back. The dismissal is unfair merely because the employer failed to comply with a fair procedure. But there was a good reason for dismissal. You may receive up to 12 months' wages as compensation for an unfair dismissal if the cause is procedural or substantive unfairness. Compensation for an unfair labour practice claim is limited to 12 months remuneration. However, for an automatically unfair dismissal, you could get up to 24 months' wages as compensation. If your dispute is not resolved after conciliation by the CCMA or the Bargaining Council, you have the option to escalate the matter to the Labour Court for adjudication. Your case may also first be referred to arbitration. If the court finds the dismissal unfair, it may award you compensation of up to 24 months remuneration. You don't need a lawyer to register a dispute with the CCMA. However, if you would like to discuss your situation or want help completing the necessary forms, give me a call on the number below.